case, run them consecutively and have them add up to 28 months. Is that right?
That is correct, Judge.
Okay. I didn't get a chance to look this morning. Was there a motion for a durational departure? Because it's going to take.
Judge, I did file a motion for durational departure.
Okay.
That was electronically filed on Wednesday, and so
Okay.
it should be in the system. If
Okay.
not, I can email a copy to the court, you Judge, right now
No.
if you need it.
I'm good. I'm good. I'll pull it up here.
And Judge,
Yep.
do you remember that case you did a mediation with Nick, Mr. Belcher's case? Remember that?
What was he charged with?
Well, he's on probation for assault, but then he got arrested and charged with having a gun. And you did a mediation. Nick was on the other side.
Right. Yeah, he asked me about that too. He said that maybe your guys' remembering of what I recommended was different from each other.
Correct. And what I have in my notes is reduce the probation case sentence, and I've got to see if I can find more information down to 30 months. And we'll agree to that. And then also the state would dismiss the new gun case as part of the plea. And it would not be a request for probation. He'll just go do that time.
I thought that was the recommendation. I was trying to pull up my paperwork to see if I wrote down what I had recommended, but I didn't see that.
Okay, again, I'm thinking a downward duration up to 30 months, a modification to 30 months on the old case, what he's on probation for, but I've got to go find. Nick didn't even remember any downward,
And what would he be looking at in the on the grid?
Well, he's already been sentenced, Judge. I got to go look at that. I don't know, but I mean, he's already been sentenced on the old case that he's on probation.
Oh, yeah. That's right. Okay. Yeah.
So I just got to go look and see what that is.
Yeah.
You hear us, Judge?
Yep, sure can.
Judge, housekeeping before we start.
Yep.
I have the journal entries in front of me. And again, I don't know what I don't know. But once we're done, I take it, I'll sign it and bring it to you. And then John can sign at his own convenience whenever whenever he's available. Would that work?
Usually what you do is you sign it, send it to me, I sign it, and I send it back to you, and then you forward it to the judge. That's normally what happens. If that's okay with you, Judge.
Yeah, that's how it goes.
Okay, that's fine. So John, whenever you're available in the next, say, 2 weeks or so.
Just come if you need me to stop by, just go ahead and email it to me. Would that be easy? What would you prefer?
I mean, are you going to be by in the next 2 weeks, I guess?
I've got to check my calendar.
If not, then I'll email to you.
It's like I just deal with daily thing, and look for the next day.
I got you. No problem. Okay, right. Fair enough.
Sounds good. All right. Let's be on the record in two cases, those being 2019 CR 1246 and 2020 CR 580, both captioned State of Kansas versus Danny Sport. Would the parties announce their appearances, please?
The state appears by and through Viet Le.
May it please the court. John Kitchen, appearing on behalf of defendant Danny Sport, who is present and in custody by video on both cases.
All right. We are here set down for a sentencing today. The record should reflect that the parties were last in court, also by Zoom back on January 4th of this year. At that time, the defendant changed his plea from one of not guilty to guilty in both of these cases. I inquired of him and accepted those. Whoops, I had that one open wrong. Let me make sure I had the date right here. No, it was January 7th. I had my last PSI open. All right, it was January 7th that the parties appeared and this all happened. I accepted those pleas and ordered a pre-sentence investigation, set it for sentencing today. I've received separate PSIs in both of these cases. The critical findings are as follows. In 2019 CR 1246, the primary count of conviction is one of possession of methamphetamine. That is a severity level 5 non-person drug felony. The defendant was found to have a criminal score of A, as in Adam. That would leave him with a presumption of prison and a presumed underlying range of 37, 40, or 42 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to post-release supervision duration of 12 months. If he was granted probation today, it would be a period of 12 months to community corrections. The second count of conviction in this case is one of attempted theft. That's a severity level 10 non-person, non-drug felony. Defendant criminal history for scoring purposes on secondary counts is I, as in Isaac. That would leave him again with a presumption of prison and a presumed underlying sentence of 5, 6, or 7 months. The same 20% good time credit and 12 months of post-release supervision. Those are the findings of the 2019-1246 case. The PSI was also received in the 2020-CR580 case. In that case, the critical findings are as follows. The sole count of conviction in this case is one of criminal possession. The primary count is one of criminal possession of a firearm. That's a severity level 8 non-person felony. The defendant's criminal history score for this case is B, as in boy. And the difference in the two is obviously the cross-counting of the convictions in the two cases. That would leave the defendant with a presumption of prison and a presumed range of 18, 19, or 20 months. Same 20% good time credit and 12 months of post-release supervision. If he were granted probation in this case, it would be a period of 18 months to community corrections. The special rule number 10 applies, which is felony bond at the time of offense. The second count of conviction in this case is one of interference with a law enforcement officer. That's a severity level 9 non-person felony. Again, for criminal history scoring purposes, secondary counts are I. That would leave him again with a presumption of prison, a presumed range of 5, 6, or 7 months, 20% good time credit, 12 months of post-release supervision duration, and 18 months of probation if that were in the cards. I would ask you first, Mr. Le, did you have an opportunity to review both of these pre-sentence investigations? Any additions, corrections, or challenges to those findings?
Judge, the state has reviewed the pre-sentence investigations and the state concurs with your findings.
All right. Mr. Kitchen, same question.
Judge, I did receive copies of both PSIs. I did deliver both copies of the PSIs to my client, Mr. Sport, at the jail. I saw him at the jail on Saturday. I believe that was January 30th, 2021. We reviewed both PSIs, and after going over both documents, my client informed me he has no objection to either PSI, and so I believe we are ready to proceed with today's sentencing.
All right, thank you. And in that vein, Mr. Kitchen, you filed a motion for a downward durational departure in both of these cases. Would you like to be heard on that?
Judge, your transmission of the volume faded, but I did file a motion for a durational departure, and that was filed on Wednesday of this week.
Correct. Would you like to be heard on that this morning?
Judge, I would just ask the court, pursuant to the plea agreement, to grant the downward departure sentence. The sentences for both cases will run consecutive, but there'll be a total controlling sentence of a 28 months sentence. There will be no, obviously, because Mr. Sport is presumptive prison, there will be no request for probation by the defense pursuant to the plea agreement. Judge, the grounds for the departure, as spelled out in both of the downward duration departures, is one, my client accepted responsibility for his actions for both cases and pled guilty. These cases did not go to trial. Number So by agreement of the parties, two is number two. And the other issues I'll spell out in my motion, Judge, if the court would like me to reiterate, but I have to go back and actually read them to get specifically to go through them all.
No, I've reviewed them and you can stand on those allegations in the motion.
Thank you, Judge.
Mr. Lay, do you have any position on defense motion or any other comments touching upon sentencing?
Judge, no, the state concurs with the defense counsel.
All right, thank you. Mr. Sport, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
Oh, well, just thank you for sending me to prison so I get rehab and stuff, start over again.
All right. Well,
Sorry for everything.
I think that is an excellent attitude to go in with this. And I'm counting on us giving you the opportunity and the resources you need to get yourself straight and and be able to come out with a really fighting chance at this. All right,
Thank you.
Mr. Kitchen, do you know any legal reason why I should not now proceed to sentencing?
I do not know of any reason, Judge. I think we can go towards sentencing.
All right. I am going to grant the defendant's motion for a downward durational departure. I'm going to adopt as the substantial and compelling reasons for that, those set out in the defendant's motion and with consideration of defense counsel's statements today. I do find that the ends of justice are served by granting this durational departure. And therefore, in case number 2019 CR1246, the defendant will be sentenced to prison for a period of 14 months on count one. If he's eligible for 20% good time credit and subject to 12 months of post-release supervision duration. As to count two, he'll be sentenced to the standard range of 6 months. Same 20% good time credit and 12 months of post-release supervision. Count two is ordered to run concurrently with count one in this case. In case number 2020-CR580, for the primary count of criminal possession of a firearm, the defendant will be sentenced to 14 months in the Department of Corrections. Again, eligible for 20% good time credit and subject to post-release supervision of 12 months. As to count two, in that case, interference with a law enforcement officer, the defendant will be sentenced to the standard range of 6 months in the Department of Corrections with the same 20% good time credit and 12 months of post-release supervision. Count two is ordered to run, I'm sorry, it's count three of the charges, but count the second count of conviction, and it is ordered to run concurrently with the primary count of conviction, which is count four. Case 2020 CR580 sentence is ordered to run consecutively to that in 2019 CR1246. That is per plea agreement. And also the court's aware that special rule number 10 applies. I do not believe that mandates consecutive sentences, but given the downward durational departure in both these cases, the court is exercising its discretion to run these consecutively. As to the costs and fees here.
I'm sorry, Judge, you cut out. Judge,
Okay. Every time I get an email that comes in during this, it cuts out. So I'll keep that in mind. All right. As to costs and fees, in case 2019 CR1246, I'm going to assess the court costs. There is no supervision fee since the defendant's not granted probation. Mr. Kitchen, do you know what your attorney's fees are going to be?
Judge, I have to calculate my time, but given the fact that Mr. Sport is going to be going to prison, pursuant to the court's order, I would ask the court to waive those fees, if possible.
All right. Well, look, there's a couple of things I'm going to do here, and I don't know if I cut out with that email or not. Here's a couple of things I'm going to do. On one of these, I'm not going to assess costs in both cases, since even though these have remained apart, these are commonly joined for sentencing purposes. And I think it would be unfair to charge him costs in both cases. I do think that he's not going to have to pay while he's in prison, but he should be responsible for some of Mr. Kitchen, although I imagine not all of them, given the work on 2 cases and having to craft a downward departure. I'm only going to assess $200 of Mr. Kitchen's fee along with the bids fee, bids application fee. He doesn't have to pay a DNA database fee because his DNA is already on file. And I don't believe the drugs were ever tested, so there isn't a KBI lab fee. So that's going to leave him basically $500 in costs. And I don't think that that should be overly burdensome during his post-release supervision. It would cost him less than $50 a month to get that done. So I think as far as costs and fees go in the case, 2019 CR 1246, he's going to get 193 in court costs, 200 in attorney fee, 100 in bids fee. All costs and fees in the 2020 case are going to be waived. All right. So, Mr. Sport, I have to tell you that you have 14 days from today to appeal anything you don't like about your sentence. You also may be able to seek expungement of these convictions following a period of time after successful completion of supervision. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand all that?
Yes, sir.
All right. You're going to be granted credit for all of the days that you've been in jail. Since these are ordered to run consecutively, I believe Mr. Lake will apply all of those to the older case. So you will already have that head start on the first of these 2 consecutive sentences, okay?
You cut out, I understand. The first, even when I came in on the 13th of October, it counts too for last, when I discounted. I was there a month. Okay.
You get credit for every day you've been in jail.
Okay.
Since they're consecutive sentences, though, you only get them in one case. So it gives you, since they're running end to end, you'll get them off the top of your first case. And so you don't get to double count it. All right. Mr. Lay, anything that you know that I failed to cover yet today?
Judge, I think you covered it all.
And Mr. Kitchen, same question.
Judge, I believe you've covered it all as well.
Okay, all right. Then we are going to be adjourned. Mr. Sport, good luck to you. I wish you the best of luck while you're in. Get the treatment you need, and so when you can get out, all of this can be behind you.
And can I say something? Thanks, John Kitchen. He was great.
He always is.
Yeah.
All right.
Good day.
Thank you for those
Thank you,
kind
Mr.
words, Mr.
Sport.
Sport.
All right.
We're adjourned.
Thank you, Judge.